Good morning. If you woke up this morning feeling anxious because you saw headlines screaming about frozen immigration benefits, mass deportations starting immediately, or every pending case being denied under a new Trump era in 2026, I need you to take a deep breath right now. Because most of what you're seeing online is incomplete, misleading, or being shared without proper context. And my job today is to walk you through exactly what is actually happening, what is rumor, what is real, and most importantly, what you need to do to protect yourself and your family during this time of confusion. My name is Saqib, and you're watching Global Immigration Updates, where we cut through the noise, the panic, and the political theater to bring you factual, verified immigration news that you can actually rely on. No fear-mongering, no clickbait, just clear information based on official sources so you can make informed decisions about your future in the United States. My name is Saqib, and you're watching Global Immigration Updates, where we cut through the noise, the panic, and the political theater to bring you factual, verified immigration news that you can actually rely on. No fear-mongering, no clickbait, just clear information based on official sources so you can make informed decisions about your future in the United States. Let me start by addressing the single biggest source of panic right now, which is the phrase immigration benefits frozen. This phrase is being shared across WhatsApp groups, TikTok videos, Instagram Reels, and Facebook posts, and it's causing genuine terror among families who have applications pending with USCIS, people waiting for work permits, individuals with adjustment of status cases in process, and anyone who depends on the immigration system functioning normally. So let's be absolutely clear about what this phrase actually means and what it does not mean. As of today, there is no executive order, no federal court ruling, and no congressional action that has legally frozen all immigration benefits across the board. USCIS, which is the agency responsible for processing most immigration applications, including green cards, work permits, naturalization, asylum, and family-based petitions, continues to operate. Their offices are open, their online systems are functioning, applications are still being received, and decisions are still being issued. If you check the USCIS processing times page right now, you will see that cases are moving through the system, though many are significantly delayed due to backlogs that have existed for years, not because of any sudden freeze. However, and this is where we need to separate fact from fiction, there have been specific policy changes and procedural shifts that are creating real delays and real uncertainty for certain categories of applicants, and these changes are being misinterpreted or exaggerated into claims that everything is frozen. Let me explain exactly what is happening so you understand the true scope of the situation. First, there have been credible reports and some official communications indicating that USCIS has paused or significantly slowed the processing of certain types of applications, particularly those related to humanitarian programs, parole processes, and discretionary benefits that were expanded or created during the previous administration. This includes programs like the CHNV parole process for Cubans, Haitians, Nicaraguans, and Venezuelans, certain temporary protected status renewals, and advance parole applications for DACA recipients in some cases. These slowdowns are real, they are affecting real people, and they are causing real harm to families who were counting on these programs to reunite with loved ones or maintain legal status. Second, there has been increased scrutiny and higher denial rates for certain types of applications, especially those that involve discretionary judgment by immigration officers. This includes things like employment-based green card applications, where officers are issuing more requests for evidence, family-based petitions, where bona fide relationship requirements are being examined more closely, and asylum cases, where credible fear interviews are being conducted with stricter standards. These changes do not constitute a freeze, but they do mean that cases that might have been approved relatively smoothly in the past are now facing additional hurdles, longer wait times, and higher chances of denial or delay. Third, and this is critically important, there have been internal policy memos and directives within immigration agencies that have not been made fully public, but that are influencing how officers make decisions on pending cases. These memos often reflect changing priorities, stricter interpretations of existing law, and directions to deny cases that fall into certain categories unless the evidence is overwhelming. Immigration attorneys across the country are reporting that they are seeing patterns in denials and delays that suggest coordinated policy shifts, even when no formal rule change has been published in the Federal Register. Now, let's talk about what pending immigration benefits actually means in practical terms, because this is another area where confusion is causing unnecessary panic. When we say immigration benefits, we're talking about a wide range of applications and petitions that people file with USCIS or other agencies. This includes family-based green card applications, employment-based green card applications, adjustment of status applications for people already in the United States, naturalization applications for people seeking citizenship, asylum applications, work permit renewals, travel document requests, visa petitions filed by employers, and many other types of cases. If you have a case pending right now, here is what you need to understand. Your case has not been automatically denied just because of policy changes or political transitions. USCIS is legally required to adjudicate applications based on the law as it exists, and while interpretations of that law can shift, the fundamental legal framework governing most immigration benefits has not changed overnight. If you filed your application properly, if you submitted all required evidence, if you paid the correct fees, and if you are eligible under the law, your case should still be processed according to normal procedures. However, normal procedures right now include significant delays, increased requests for additional evidence, longer interview wait times, and in some cases, unexplained pauses that leave applicants in limbo for months or even years. This is not a freeze in the legal sense, but for families waiting for work authorization, for individuals who cannot travel because their advance parole is pending, or for people whose status expires while they wait for a decision, the practical effect feels very much like being frozen in place with no clear path forward. Let me address some of the most dangerous rumors circulating right now so we can separate fact from fear. Rumor number 1 is that all pending green card applications filed before a certain date will be automatically denied. This is false. There is no legal mechanism that allows USCIS to deny applications simply because they were filed during a previous administration or before a policy change. Each application must be reviewed on its individual merits according to the law. If your green card application is denied, you have the right to appeal, to file a motion to reconsider, or in some cases to reapply. And the denial must be based on a legal ground, not on political timing. Rumor number 2 is that USCIS has stopped issuing work permits entirely. This is also false. Work permits, also known as employment authorization documents, or EADs, are still being issued for eligible applicants. However, processing times for EAD renewals have increased dramatically in many service centers, and some applicants are experiencing gaps in their work authorization because their renewals are not being processed before their current EAD expires. This is a serious problem that is affecting people's ability to work legally and support their families, but it is not the same as a complete freeze on all work permits. Rumor number 3 is that everyone with a pending asylum case will be deported immediately. This is false and reflects a fundamental misunderstanding of how asylum and deportation proceedings work. If you have a pending asylum application with USCIS, that application will continue to be processed, though processing times are extremely long and denials have increased. If you are in removal proceedings before an immigration judge and you have applied for asylum as a defense against deportation, your case will proceed through the immigration court system, and you have the right to present your case, to have legal representation, and to appeal negative decisions. There is no legal authority for mass, immediate deportations of people with pending cases without going through proper legal procedures. Rumor number 4 is that traveling outside the United States with a pending application will result in automatic abandonment of your case. This is partially true in some situations and completely false in others, so let me clarify. If you have a pending adjustment of status application and you leave the United States without obtaining advance parole first, your application will be considered abandoned in most cases. This has always been the rule and it has not changed. However, if you have advance parole and it has been approved, you can travel and return without abandoning your application. The problem right now is that advance parole applications are experiencing severe delays, and some applicants are being told informally that approvals are on hold, which leaves people unable to travel for family emergencies, work obligations, or other critical reasons. Now let's talk about what Trump-era 2026 actually means in the context of this video title, because this phrase is being used to create fear without explaining the legal and procedural realities of how immigration policy actually changes in the United States. Presidential administrations can and do influence immigration policy through executive orders, agency directives, changes to regulations, and enforcement priorities. However, most significant changes to immigration law require congressional action, and even executive actions must go through specific legal processes, including public notice and comment periods for most regulatory changes. What we are seeing right now is a combination of immediate executive actions that can be implemented quickly, such as changes to enforcement priorities and internal agency guidance, and longer-term regulatory changes that are being proposed or drafted but have not yet taken effect. For example, if a new regulation is proposed that would change eligibility requirements for a particular type of visa or benefit, that regulation must be published in the Federal Register. The public must be given an opportunity to submit comments, those comments must be reviewed, and then a final rule must be published before the change becomes legally binding. This process typically takes months, and during that time, the old rules remain in effect. This means that if you are eligible for an immigration benefit under current law, you remain eligible until and unless that law is officially changed through the proper legal process. Rumors about immediate, sweeping changes that eliminate entire categories of immigration benefits overnight are almost always exaggerated or false, because that is simply not how the legal system works. There are checks and balances, there are administrative procedures, and there are courts that can block changes that violate the law or the Constitution. However, I do not want to minimize the real challenges and real dangers that exist right now. Even without formal legal changes, shifts in how existing laws are interpreted and applied can have devastating effects on real people. An immigration officer who is instructed to apply a stricter standard when evaluating evidence can deny a case that would have been approved under a more lenient interpretation. An asylum officer who is told to prioritize certain factors over others can find that an applicant does not meet the credible fear standard, even when their story has not changed. These discretionary decisions happen every day, and they are influenced by policy guidance that comes from political leadership. Let me now explain who is most affected by the current situation and who has less to worry about, because broad panic helps no one, and precise information is what actually protects people. If you have a pending application based on a humanitarian program that was created or expanded in recent years, such as certain parole processes, you are at higher risk of delays, additional scrutiny, or denial. If you are applying for a discretionary benefit where the decision depends heavily on an officer's judgment, such as advance parole or certain types of waivers, you should expect longer processing times and potentially higher denial rates. If you have a pending family-based green card application and your relationship is clearly bona fide with strong supporting evidence, your case should proceed normally, though you may experience delays. If you are applying for naturalization and you meet all the requirements, including continuous residence, physical presence, good moral character, and English and civics knowledge, your application should be processed according to standard procedures. If you have a pending employment-based green card application sponsored by a legitimate employer and you have maintained lawful status, your case should continue to move forward, though you may face requests for additional evidence. If you are currently in removal proceedings and you have a valid defense, such as asylum, cancellation of removal, or adjustment of status through a family member, your case will go through the immigration court system, where you have due process rights, including the right to a hearing, the right to present evidence, and the right to appeal. Courts are independent of executive branch policy changes, and immigration judges are required to apply the law as written, though their interpretations can certainly be influenced by changing precedents and Board of Immigration Appeals decisions. Let me be very clear about what you should do right now if you have a pending immigration case or if you are considering filing an application. First, do not panic and do not make rash decisions based on rumors or social media posts. Immigration decisions are among the most important decisions you will make in your life, and they should be based on accurate information and professional guidance, not fear. Second, check the status of your case regularly through official channels. If you have a case with USCIS, log in to your online account or call the USCIS Contact Center to verify that your case is still active and to check for any updates or requests for evidence. Third, if you receive any communication from USCIS or any other immigration agency, read it carefully and respond by the deadline if action is required. Missing a deadline for responding to a request for evidence or a notice to appear for an interview can result in your case being denied or abandoned. Fourth, if you are eligible to file an application now and you have been waiting for the right time, consider consulting with a qualified immigration attorney to evaluate whether filing sooner rather than later makes sense for your situation. Immigration law is complex, and what is best for one person may not be best for another. Fifth, keep copies of all documents related to your immigration case in a safe place, including receipts, notices, correspondence, and evidence you submitted. If you need to follow up on your case, refile, or appeal a decision, having complete records is essential. Sixth, if you are experiencing a significant delay or if you believe your case has been improperly denied, consider seeking help from a reputable immigration attorney who can evaluate your options, which may include filing a mandamus lawsuit to compel action, filing an appeal, or submitting a motion to reopen or reconsider. Seventh, stay informed by checking official sources regularly, including the USCIS website, the State Department website, and announcements from immigration advocacy organizations that have a track record of accuracy and reliability. Avoid relying on information from social media, unofficial Telegram groups, or individuals who claim to have inside information but cannot provide credible sources. Immigration policy changes are almost always announced through official channels, and verifying information before acting on it can prevent costly mistakes. Let me also address something that many people are afraid to talk about openly, which is the emotional and psychological toll of living in uncertainty while your immigration case is pending. It is completely normal to feel anxious, frustrated, angry, or hopeless when you are waiting for a decision that will determine whether you can stay in the country where you have built your life, whether you can continue working in your job, whether your family can stay together, or whether you will be forced to return to a place where you may face danger or separation from loved ones. These feelings are valid, and you should not be ashamed of them. However, it is also important to remember that uncertainty is a part of the immigration process that has always existed. And while the current political environment is creating additional stress, the fundamental truth remains that most people who are eligible for immigration benefits under the law will eventually receive those benefits, even if the process takes longer and is more difficult than it should be. The immigration system is slow, it is frustrating, it is often unfair, and it is deeply broken in many ways. But it is not completely closed, and people continue to receive approvals, green cards, work permits, and citizenship even during times of restrictive policy. One more thing I want to emphasize before we finish today is the importance of community and support during difficult times. If you are going through the immigration process, you are not alone. There are millions of people in the United States and around the world who are facing the same fears, the same delays, and the same uncertainty. Connecting with others who understand your situation, whether through local community organizations, religious groups, online forums moderated by reputable organizations, or support groups led by immigration attorneys, can provide emotional support, practical advice, and a sense of solidarity that makes the journey more bearable. Finally, let me remind you that immigration rules and policies do not usually change overnight, and even when changes are announced, there are legal processes, court challenges, and implementation timelines that provide opportunities for people to understand what is happening and to take appropriate action. The most important thing you can do is stay informed, stay calm, verify information before believing or sharing it, and seek professional help when you need guidance on your specific situation. If this video has helped you understand what is really happening with pending immigration benefits, if it has reduced your anxiety even a little bit, or if you now feel more prepared to navigate the current situation, I ask you to do 3 things. First, subscribe to Global Immigration Updates and turn on notifications so you receive accurate, fact-based immigration news without the rumors and panic. Second, share this video with anyone you know who might be worried or confused about their immigration case right now. And third, leave your immigration-related questions in the comments below. I read every comment, and while I cannot provide personal legal advice, I can address common concerns in future videos and point you toward reliable resources that can help. Thank you for watching, and remember, staying informed is your best protection in uncertain times.